If you're buying or selling property in Florida, you'll hear a lot of legal terms, and two of the most important are grantor and grantee. Understanding the difference isn't just legal jargon, it's essential to making sure your real estate transaction is valid and protected. Hi, I'm Anila Rasul, owner and lead attorney at ASR Law Firm in Boca Raton, Florida. In this short video, I'm going to explain the difference between grantor and grantee in Florida real estate transactions, their key responsibilities, and why getting it right protects your property rights. Let's start with grantor. The grantor is typically the seller, the person or entity who currently owns the property and is transferring ownership. The grantor's main responsibilities will include delivering a valid deed, providing clear title free of liens or undisclosed claims, and assuring the grantee's right to enjoy the property without third-party intervention, as well as handing over all the necessary documents at the closing. Now, the grantee is usually the buyer, the person who is receiving the ownership of the property. The grantee's responsibilities include ensuring the grantor truly owns the property, meeting all contractual obligations such as paying the purchase price and completing inspections, recording the deed to protect their own ownership rights, and assuming all the ongoing duties such as mortgage payments, insurance, and property taxes. In Florida, property is transferred through a deed. The most common ones are the warranty deed, which offers the strongest protection and is usually used in financed purchases, a quitclaim deed, which provides no guarantees, but it's often used between family transfers or estate planning, and a special warranty deed, which covers only claims that arose during the grantor's ownership. At ASR Law Firm, we receive numerous questions about this topic. Here are some of the most common ones we receive. First, is the grantor the buyer or the seller? In Florida real estate transactions, the grantor is usually the seller. 2, is the grantee the borrower? Sometimes, but not always. The grantee receives the property while the borrower receives financing. Therefore, if the grantee is purchasing the property with cash and not via a loan, then the grantee will not be considered the borrower as well. And third, what's the difference between a grantee and a payee? The grantee receives the property and the payee receives payment. Think the lender or the bank. In every Florida real estate transaction, both the grantor and the grantee play a very vital role. So understanding these roles and their responsibilities and working with a qualified real estate attorney helps ensure that your investment is secured and your transaction runs smoothly. So if you're preparing to buy or sell property in Florida and you want to protect your interest, please feel free to contact us. We'd be so happy to help.